Hello, everybody. My name is Jan Miller. I'm a partner in the business litigation section here at TC, and I'm here today to talk about what to do when the government comes a-knocking. Let me give you a little bit of a background on me before I get into the substance of what I'm talking about today. I've been at Thompson Coburn for about 7.5 years now. For about 17 years prior to that, I was a federal prosecutor, first in Maryland and then in central Illinois. So because of that background, when a subpoena shows up, I tend to be one of the guys they call here. About half of my practice, roughly, deals with government investigations of some sort or another. And I know that what I found is that companies, the first time you go through one of these things, it can be very stressful. It is unlike anything else that you've been through before. And so I thought I'd just sort of go over some of the basics regarding what you can expect regarding a government investigation. We'll talk about where they come from, how they work, probably most importantly what you should do, what your company should do, and some very important things that you should not do to keep yourself out of trouble, what the possible outcomes are, and how you can minimize the bad outcomes. Now, one of the things you can think about, and one of the things that I get asked about when I talk about this topic is why, our company's clean, we do things the right way, why do I have to worry about this? The government is never going to come knocking on our door. You can never be sure about that. Absolutely never be sure. Because anything, and we're going to talk about in a minute where these things all come from, but anything can trigger a federal investigation. And you just never know. No matter how good a corporate citizen you are, it is possible that one day a federal agent, an FBI agent, will show up with a subpoena. So why do we want to talk about these things? Well, the costs of an investigation, frankly, can be crushing. Depends, of course, it varies dramatically from investigation to investigation, but it can have a tremendous impact on your company even beyond the financial costs. You get business disruption. It's amazing how much disruption an investigation can cause within your business. It's the type of thing that just can kind of hang over you as a black cloud if you let it. You lose productivity, takes a personal toll on the people who are involved in it. Obviously, one of the things that any client is concerned about, as well as this going to be out in the public, is there going to be a press release about this because it could hurt our company's reputation. Obviously, the attorney's fees can run quite high, and, of course, potentially an ultimate settlement that you have to pay to the government. So, knowing how the investigators work and what they look for and what you can do can help minimize. It will not make these impacts go away. But it can help keep them to at least a reasonable level so that you're not spending every evening pulling your hair out. Another reason why this is very important is if your company does any business with the federal government, and I don't know how many of your companies do or not, but there are lots of companies that will have a contract here or there with the federal government, and the government is the only payer you will ever have who could subpoena you, indict you, and send you to jail. So it really changes the dynamic, obviously, when it's not just a regular business negotiation when they come looking. And because of the incredible power that the government has, it really, the initial steps you take whenever there is a government inquiry, even if it's just on an audit level, is very, very important. Because you want to stop the snowball from rolling down the hill before it gets started. So, one of the questions that comes up, and again, I referred to this a few moments ago, is how do these investigations get started? Because again, people often think they're never going to be in this situation. And the bottom line is, federal investigations can start from a whole host of different avenues. A routine audit. Now, these are going to be generally with cases where the government is your customer, and any government contract is going to have a right to audit. And any government agency is required to do audits on something of a regular basis. Some of them are better at it than others. Some of them are more regular at it than others. But the bottom line is, if you do any business with the government at all, you can expect at some time a group of auditors will come in. And this is one of the most common ways that an investigation can get started. And it is very, very important, for the reasons I just said a moment ago, that these things can really snowball and have dramatic consequences at the end of the day. It's very important to react to these, what appear to be a routine audit, seriously. I had a situation with a client who they were involved in one government contract. They had never been involved in a government contract before. Auditors came in and did an audit of them at one point, and they kind of gave the audit. They didn't call outside counsel. They just dealt with the auditors, auditor to auditor, their accounting department, and they kind of gave the government auditors the back of their hand. I mean, they gave them some information, but they didn't really take the time to really dig and get the information that the auditors were really asking for. Well, that ticked the auditors off. And so they went back to their office and they handed it up the chain to the office of the Inspector General. And that started us on a completely different path that eventually turned out fine, but it ran into all those problems we saw on the previous slide. A lot more money, tremendous business disruption, a lot of people losing a lot of sleep over, etc. And those things might have been avoided if there was a recognition up front that any time the government comes in for an audit, you can't just treat it as a routine. Answer their questions fully, make them satisfied when they go out, before they go out the door. There are some situations where you're required to self-report. Again, this falls within the government contracting area, but if the contract is above a certain amount of money, if you find out somehow, anyway, through an internal audit or an internal compliance system or whatever, that you have received monies that you shouldn't have received, you got overpaid by the government somehow, you are required to self-report that to the government. And that could start an investigation on its own, obviously. Whistleblowers. We've all heard about them in the news. They are often former employees. And it's, again, remarkable how much trouble they can cause as far as getting an investigation really going. I had another situation with a client where they had hired this new guy into an executive position, and he was not working out. There were a whole lot of problems with him. About 8 months into his tenure, and this was a publicly traded company, he did up a memo and sent it up to the CFO saying you're handling this particular accounting issue incorrectly, in his opinion. And frankly, the company, looked into it and looked at it and said, no, you don't know what you're talking about. This is just fine. Well, about 4 months go by, guy's up for his annual review, and they say it's just not working out. We're going to have to show you the door. 2 weeks later, he sends an email after he's shown the door. He sends or he's told he's leaving in 2 weeks. He sends an email to the CEO and basically says in the email, fairly directly, you remember this accounting thing that I raised? I think you're in violation of Sarbanes-Oxley, and I'm going to take it to the SEC, unless, of course, you pay me $500,000 as a severance payment. You would think that, of course, the company told him, there's no way, we're not paying you a dime, and the guy sent a complaint to the SEC. Now, you would think that with that background, it would be a fairly straightforward open and shut case for the SEC. I remember the first meeting I had. I had to go up to Chicago SEC office and meet with the attorney and the chief investigator. It was early on. They had issued a subpoena. And I showed them the email. I found out they had already seen it. And my basic question to them was, this guy committed extortion or attempted to. And how is it that you're going to require our company to jump through all these hoops? And they were like, we don't care. He made an allegation. We're going to have to look into it. Too bad. 2 years later, they finally closed the investigation with no enforcement because nothing had been done wrong. The company was right to begin with. But again, You never know where these things are going to come from or how long it's going to take to resolve them. A customer can be the whistleblower. Just because you don't do government contracting work, and obviously, and this one I was just talking about was not a government contract situation. It was just a publicly traded company, so they were under Sarbanes-Oxley. Customer can report someone to the government if they feel they're being defrauded somehow. And of course, a competitor can try and gain a little competitive advantage by trying to send something to the government. So there's any number of routes that this can take. And the initial information might be very minimal, but as I mentioned a few moments ago regarding the first example I gave you, even very small questions can start to take on a life of their own. And like anything else that's done by a bureaucracy or a large organization of any sort, the more time, the more resources that are put into the investigation, the longer it's going to go and the harder it's going to be to stop. It really does have a snowball effect. So you want to try and cut them off at the beginning as quickly as you possibly can. How long do investigations last? There is no single answer. They tend to be lengthy. Lengthy is in the eye of the beholder, but you're going to expect at least months, if not years, before a resolution. The government does nothing fast. And even when you think you finally have a resolution in hand, even that, finalizing the resolution, can take a tremendous amount of time. We'll talk a minute about the different agencies that get involved and who you have to deal with, but oftentimes what happens is wherever the referral comes from, there's usually a local office of some sort that's doing most of the heavy lifting on the government side, the local U.S. Attorney's Office or whoever. And what often happens is you can work out a settlement, you work out an agreement with the local folks who are actually doing the work, but especially if it's a civil matter, which is what you hope to keep it, they have to go back to Washington to their individual headquarters to get approval, and that could take a tremendous amount of time. It's really amazing because, of course, they have to do that for everything around the country. You're just one of many that they're dealing with. So even when you think it's over, it sometimes isn't over. It ain't over till it's over, as Yogi said. Who could be investigated? This gets to the thought of, well, we're a good company, we do the right thing, there's no way this is ever going to happen to us. Not necessarily true. People often ask me, based on my previous experience, well, how much, what's the threshold? If you cheat somebody out of $1, are they going to look into it? Well, probably not. Where's the line? Where's the line? There is no line. Okay? There is no line. Different offices, different U.S. attorneys' offices, for example, do have prosecutorial guidelines that they're supposed to follow internally. It varies from office to office to office. For example, when I was in AUSA in Maryland, we wouldn't think of looking at a fraud case unless the loss was at least $500,000, because we just didn't have time to deal with anything smaller than that. I don't know what that is. Now, that didn't mean we didn't do it sometimes. Sometimes there were other factors that we would take into account to get us to look at a smaller case. But other offices have different guidelines. So you can't count on not getting pulled into one of these things just because there's not a lot of money involved. It certainly is a factor, but, and as I said, it's not limited to bad guys. It's not limited to people with bad intent. These investigations are not always criminal. You hope to keep them from ever becoming criminal. But administrative or civil investigations can occur and be lengthy and be just as disruptive as any other type of investigation, simply because of some accounting error or something of that nature. Of course, if you're dealing with the government, if you use wire transfers or send anything through the mail, you can be investigated. Because once you send a wire transfer or anything through the mail, you could be, from the government's eyes, committing wire fraud or mail fraud. The wire fraud, that's often what I get asked also is, well, what possible crime could they be looking at here? And it's not just limited to if you're receiving money from the government. It could be customer turning you in as well. The mail fraud and wire fraud statutes are the federal prosecutor's best friend because they are a catch-all type of thing. The minute anything goes through the U.S. mails, even if the thing that's going through the U.S. mails is not itself a false statement, if it was done as part of the course of conduct, part of the business contract or whatever that's being looked into, you have a potential mail fraud. Same thing with wire. If something is through the internet or funds are wired across state lines, you potentially have wire fraud. So that's usually, if you're talking about a criminal investigation, those are usually the statutes they're looking at. Government agencies. What government agencies are we talking about here? Well, there's any number of them. Of course, they're lousy with acronyms in the government, of course. And any number of agencies can be involved. Sometimes you can have multiple agencies involved on the same investigation. Every agency has its own Office of Inspector General. And usually, again, if it's a government contract thing, that's going to be the first agency that gets involved, because they're the ones that the auditors report to. They're the ones who are supposed to be the watchdogs for that agency. For example, if your company has a contract, does something for the Postal Service, the Postal Service has an Office of Inspector General, and if something odd comes up in an audit, or if they get some sort of lead or referral to them, that's where it's going to go, is the OIG for the Postal Service. And so that's probably going to be the first step. The real big investigative agencies, the ones who tend to do the criminal investigations, or the really big civil ones, of course, are the FBI, which everybody is familiar with, and again, the Postal Inspection Service, the U.S. Postal Inspection Service. People are often very surprised to find out that the Postal Inspection Service is doing the criminal investigation, and they wonder, why in the world is that happening? This has nothing to do, we're not in contract with the Postal Service. Why are they looking at this? Because of mail fraud. The FBI can investigate mail fraud, so can the Postal Inspection Service. And so those are usually the types of investigations that companies are subject to or targets of. If one of the big investigative agencies gets involved, it's usually one of those two. Now, to go to court, and we're going to talk a minute about the different types of investigations that there can be. But if you're talking about one where potentially you're going to court, either civilly or criminally, if that's the goal of the investigation at the end of the day, whatever agency is doing the investigating has to go through the Department of Justice, the local U.S. Attorney's Office. The OIGs themselves do not have the authority to bring suit against your company for example, a False Claims Act case. They certainly don't have authority to try and bring an indictment against anybody. They got to go to the DOJ for that. What is the interaction between these agencies? Well, again, the OIG's job is to investigate. And one thing that's important to keep in mind is this. Again, this falls into if you're doing any contract work with the government. The agenda of the OIG, whoever is assigned from the OIG, is very, very different than the agenda of the main contract person in the government that your company is having contact with. It is very common when one of these OIG investigations starts, we'll go in and we'll talk to the company, and we'll talk to the main person in the company who's the main contact with the government. And they will say, there's nothing to this. The contracting officer, that's the title of the government person on the other side, contracting officer loves us. They think we're wonderful. They think we walk on water. They've never complained about this. I don't understand why this is even coming up. That's a very dangerous attitude to have, because the OIG doesn't care what the contracting officer says. The OIG is there not just to investigate the companies that the government is dealing with. The OIG is there to oversee their own people too. And so it could be that the contracting officer did something wrong here that the OIG is going to be looking at. Additionally, again, their agenda is very different. The contracting officer, his or her job is to get the goods or services done in a timely manner within the contract. That's what they care about. They don't care about necessarily, they're supposed to, but they certainly don't put as high a priority on things like following all the regulations. Okay? They want to get their product, they want to get their service. The OIG doesn't care about that. The OIG cares entirely about the regulations and the terms of the contract, and were they followed or not. So it's two very different agendas. What about the interaction between the OIG and the big investigative agencies like FBI? Well, as I put on here, if one of the BIAs is called in, that's potentially a larger case that you're looking at here. You know, if it's a regulatory problem, if it's a relatively minor potential problem, the OIG is probably going to handle it themselves. If the OIG reaches out and gets the FBI interested, then you could have a really large matter on your hands. And so your antennas start to go up if that's going on. And again, the role of the DOJ or the USAO, the way it works is this. OIG might start an investigation. They realize it's something large going on here, civil or criminal. They go to the FBI. They present it to the FBI. The FBI gets interested and says, okay, there's something worth taking our time to look at here. They then start doing their investigation. They will get to a point, sometimes very early, sometimes later on, where they feel like we really got something here and we want to get the U.S. Attorney's Office involved. So the FBI agent will go track down his or her favorite assistant U.S. attorney in the local U.S. Attorney's Office and pitch the case to them and try and get the U.S. Attorney's Office to open a file there. Once the U.S. Attorney's Office is involved, they're the ones who run the show. They're not the ones who are out there on the street, but anything that's done in the investigation at that point is going to be blessed or not by the assistant U.S. attorney in charge of the case. Okay, so that's the interaction. I did forget to say at the beginning of this, I tend to just talk and talk and talk. So if anybody has any questions, please throw your hand up. I'm happy to stop and interrupt myself at any point along the way. Well, not interrupt myself, allow you to interrupt me. All right, so what are the typical steps in investigation? We've talked about where they come from. We've talked about sort of the bureaucratic setup. What sort of things happen in an investigation? Well, there is no one way that these are carried out. These are some of the things that can start an investigation off, or at least some of the things that you will see from your side the first time you find out there's an investigation going on of your company. It might be an informal request for information. For example, the SEC does that a lot. And the reason the SEC does that a lot is because they do recognize, if you're a publicly traded company, if you get a subpoena from the SEC, that is a reportable occurrence. Your company is going to have to report in its quarterly reporting, that sort of thing, that you received a subpoena from the SEC. So they do tend to take that into account. And so they will, a lot of times, they will make an informal request first, which is not a reportable event, necessarily. And so sometimes they play a little nice, at least at the beginning, and allow you to do that first before things start becoming public. They want to see if there's really anything to it. Second most onerous way for these things to start is for a subpoena. And this is probably the most common. The most common thing that I see coming across my desk is getting a phone call from a client or getting a phone call from one of my corporate partners who's gotten a phone call from his or her client saying, somebody just showed up with a subpoena, what do we do? We'll talk about what to do in a minute, but a subpoena basically is just, for those of you who don't know, in this situation, is going to be a document that commands you to turn over certain information, documentation. You usually don't have to do it right then and there. It gives you a period of time to respond to it. But that's obviously an indication that you've got an investigation on your hands. Search warrant. Well, that's obviously a more problematic and troubling step. First of all, a search warrant indicates we're obviously in a criminal investigation at this point because you can't use search warrants for a civil investigation. It also indicates that a judge has ruled that there is probable cause to believe that on your premises there is evidence of a crime. It also indicates that this case has probably been percolating along for a while, because it's relatively rare that in a white-collar investigation, which is what we're talking about here, it's relatively rare that their first step is going to be to execute a search warrant. There's probably been months of investigation going on prior to this thing being issued. So you got a big old problem on your hand if they show up with a search warrant. Interviews, you can find out about an investigation because one of your employees comes in and says, the weirdest thing just happened to me this morning. I was getting ready to leave for work at 7:30. There's a knock on my door, and there's an FBI agent there wanting to talk to me. Yeah, that happens quite a bit. And so that's sometimes the first way you learn about it. Grand jury, again, is something that is usually later on. It means it's a criminal investigation. Grand juries cannot be used to pursue civil actions. If it's a grand jury investigation, it means the decision has already been made. We're trying to try and make a criminal case out of this. What goes on in the grand jury is secret by law. However, you often find out that grand juries are going on because of the witnesses who receive the grand jury subpoenas. The only in the grand jury room, the people in the grand jury room are the grand jurors, the court reporter, the prosecutor, and the witness who's testifying at that time before the grand jury. There's no judge in there. The agents, the investigative agents, are not allowed in there unless they're the witness testifying. Okay? And nobody in that room is allowed to talk about what happens in that room except the witness. The witness is allowed to tell whoever he or she wants, hey, I was in the grand jury and this is what I said. So usually the way you find out about that is, unless you receive or your company receives a grand jury subpoena itself, so again, someone will come to you and say, I got a subpoena to appear in front of the grand jury. All right. Generally speaking, and we're going to get into some specifics in a couple of minutes, what is your reaction? What should your reaction to be to any of these investigative steps? Well, you want to cooperate with the investigation. Now, how you cooperate, how deeply you cooperate, exactly what you do to cooperate is going to be more of a case-by-case thing. But it's relatively rare, in my opinion. Reasonable minds can differ on this. But it's relatively rare that the best thing to do when you initially find out there's an investigation of your company is to tell the government to go pound sand. That tends to tick them off. And you don't want to tick off somebody with subpoena power. So you want to, at least initially, be in a cooperative mode with the investigation. You need to do, and we're going to talk more about this in a few minutes, you need to do an internal investigation. This is where the disruption starts coming. This is where the attorney's fees start mounting up. But I promise you, as I could get struck down if this is a lie, it's the most important thing to do if you're being investigated. I'll talk more about internal investigations in a minute. You often have to review a massive volume of documents, including electronic data, and that's really what makes the internal investigation so damn expensive. That's what makes all litigation these days. We were just talking about this over lunch. So damn expensive now is the amount of data that is there that needs to be reviewed, and you often have to review numerous employees as part of the internal investigation. What do you want to do? Why do you want to do an internal investigation? What are the goals of an internal investigation? Well, I mean, it's pretty straightforward. You want to find out what happened and why, or how. You want to find out, and when I say what happened, exactly what happened. Who sent in the quote-unquote false claim? How did that false claim come to be? Is it merely a mistake? When I say the why, that's a very important question. Was this a mistake, or was there intent involved here? Because that will have a big impact on where you end up at the end of the day. You want to do this so that you place your company in a position to respond to the government, or even better, to proactively go to the government and say, we know you're looking at this. Let us tell you why you shouldn't waste any of your time on this. We've put all this information together. Here you go. Let me know if you have any additional questions. If you can get yourself to that point where you get ahead of the government and you're proactively giving them information to show them why they don't need to make a big deal out of this thing, that's the best result you can get out of an internal investigation. And obviously, you also want to determine what steps you need to take to make sure this never happens again, because you don't want to have this disruption to your business again. Even if it's a minor thing, if there are simple steps you can take to make sure that next time the auditors come, they're not going to be thrown off by this, you want to take those steps. And there's no way to figure out exactly what you need to do until you found out what happened and why. All right. I've talked a little bit about three categories of outcomes, a little bit about this, but let me go into a little more detail. There are basically three kinds of investigation, okay? The first is an administrative. This is from least serious to most serious. The first is an administrative investigation, and this is something usually that just stays at the OIG or auditor's level. Okay? It doesn't involve going to court. It doesn't involve Civil False Claims Act, which I'll get to in a minute. And it certainly doesn't involve any criminal penalties. This is usually the only time you're going to see this is either if you're a publicly traded company, it's an SEC administrative issue, or if you are a government contractor, if you're doing work for the government, it could be administrative along those lines. And what you're dealing with there are things like repayment of monies you shouldn't have gotten, potentially usually the worst possible thing you might be looking at, and what you try to avoid is debarment. If you're a government contractor, that's the death of your company if that's a large part of your income. And a CIA, a corporate integrity agreement. Sometimes the government, to sign off on the administrative settlement, will say, okay, you got to pay us back. We figured out that you got overpaid, $650,000. You need to pay us that back. And you need to sign this corporate integrity agreement that says you're going to take the following steps over the next 6 months to make sure this never occurs again. And you're going to have to report back to us once a year for the next 3 years, giving us all of this information to show us you're following the CIA. That's, again, something you want to try to avoid because it is expensive. And it's kind of a pain to have them hanging over your head for 3 years. Again, the best way to avoid debarment, the best way to avoid a CIA is to do your own thorough internal investigation so you can answer the questions for the government before they come to you and say, we've already taken this step and this step and this step and this step to remedy this. We don't need to do anything else. The next most serious category would be a civil investigation, most common being a Civil False Claims Act investigation, but it can be any type of civil investigation, civil fraud. False Claims Act, again, relates to government contract stuff, and what it basically says is, if you ask for more money from the government than you are entitled to, you have violated the False Claims Act. And the penalties for that are up to treble damages, so if you got overpaid $100,000, $300,000, and a fine of up to $15,000 per false statement. That can run into millions of dollars, believe it or not. For example, this often comes up. We do a lot of work for our healthcare clients here, and if they're doing Medicare work, they're sending in submissions to the government, and every U.S. Attorney's Office has a Medicare fraud team, and they're constantly looking for bad coding, improper codes that are sent in, things of that nature. And if they find one that has been going on for, let's say, 2 years, there's a glitch in the computer system at the hospital, and so instead of coding A, they've been coding it B, which costs another $25 per procedure, and that's been going on for 2 years. Every time they send in a bill for code B, $15,000, $15,000, $15,000, $15,000, it can get into the millions very, very quickly. So you want to try and stay away from that. This is, again, to get into this level, DOJ's got to be involved. Department of Justice, U.S. Attorney's Office has to be involved to get into anything in court. And then, of course, the thing you absolutely want to avoid under any circumstances is a criminal outcome, charges being brought. You really want to do anything you possibly can to stay out of that category, because when you're in this category, in the civil category, you're negotiating about what the final payment is. You're negotiating what is the actual loss here. What's the multiplier we're going to settle so we don't get 3 times damages, maybe we only get 1.5. You can waive the fines, all of that. Once you're here, you're desperately trying to get it back to here. Okay? You will pay anything to get it back to here. Trust me. All right? The problem is, once it goes to here, they really don't want to put it back to here. Okay? They don't like the government. I actually have a situation like this right now that I'm trying to get resolved back here. The government does not like, especially assistant U.S. attorneys, they do not like to be in a position where someone could look at them and say, you let that person or that company buy their way out of jail. If there's a criminal violation, it should be prosecuted as a criminal violation. And if they come to you and say, we'll pay treble damages at $15,000 per statement, just don't indict us, that's a hard sell once they've crossed over this line. What determines, therefore, which category you end up in? Because that's the $100,000 question or the $100 million question. Well, many factors can be considered. All right, none of them is necessarily the factor. But they're going to look at a number of things. They are going to look at the amount of money involved. Obviously, the more money that's involved, the more likely you're going to get into a more serious category. Okay? They're going to look at the personnel involved. What do I mean by that? Well, if the act, whatever it was performed by somebody just putting code into a computer, that's one thing. If the CFO signed off on it, that's quite another thing. The higher up the problem goes in the company, the more likely it is you're going to get into civil or criminal land. Prior conduct of the company, they're going to look at that. Are you a good corporate citizen? Have you been investigated before? If this is a repeating pattern, it's likely that the investigation is going to get more serious with each time. What's the impact on the public? These are public servants. They do look at that sort of thing. We're a whole mess of people defrauded here. If it's a government contract, for example, the public can also be the governmental consumer. If it's a military contract and something was done that put our troops in danger, you're not getting off with an administrative investigation. Okay? And cooperation. That's why I say you rarely want to say at the beginning, pound sand government. Because one of the things they most look at, and it's just human nature if you think about it, if you've been in there early and often, trying to cooperate to the extent you can, and rather than, and again, different people, you talk to another lawyer, you might get different advice. But my advice to my clients is, don't make the government jump through hoops that you know they're going to jump through if you have to make them jump through it, because you're just going to tick them off. If you're going to end up having to give them this information anyway, don't make them draft a subpoena unless you need it for some particular reason, because of Privacy Act or something like that. Don't make them do that. It's going to come back to haunt you later when they ultimately decide what to do with you. But probably if I were to pick one of any factor, it's the government's view of the intent of the actors. And it simply boils down to, was this an honest mistake or negligence, or was this criminal conduct from the get-go? Was this somebody trying to do something that they knew they shouldn't be doing? Okay? And that's very gray. That's very gray. Before we get there. And this is why this factor right here is why, in my opinion, is the single most important reason to do a thorough, timely internal investigation. Because when it comes down to it, if you're dealing with the government, with the AUSA or whoever it is, be it about whether you're going to get a CIA or not, whether it's going to be civil versus administrative versus criminal versus civil, whatever ultimate thing you're dealing with the government, negotiating with the government, they're going to keep coming back to this. And so if you have done a thorough, timely internal investigation, and you could show them through relevant emails, you can show them through course of conduct of others in the company, you could show them because you've dug through the computer stuff and you found the glitch that caused this problem. If you could show them that there was no intent to defraud anyone here, that's the best argument you can make to them. Any questions so far?
What do you do when they're guilty of sin?
It's a very good question. It's going to depend on, it's going to depend on a number of things. If I am the company's representative, if I am representing the company, and we find out that the CFO was guilty of sin, I'm going to recommend to my client, the company, that they give the CFO to the government. Because my representation is for the company. And if the CFO did this without knowledge of the CEO or the COO or whatever else, they got to live with those consequences.
Just up the ante, say the CEO, the CEO.
There you get into a very tricky situation.
I know you do.
Because then you're dealing with, well, who's the client? Is the CEO the company or not? Normally what you would do, of course, is you go to the board of directors. And the board of directors decides. That's really what it boils down to. I mean, at that point, again, from the company's lawyer's perspective, again, you have to look at all the details. But generally speaking, if the CEO is dirty and my client is the company, my recommendation to the board of directors is going to be, you got to get rid of the CEO and he's on his own. If the board of directors says, no, we're not doing that, then obviously I keep representing my client and I do what they need me to do. However, I will not cover up. The company can't cover up and all that sort of thing. But the question at that point is, do you turn over affirmatively all this information you have on the CEO to the government or do you not? That's the client's decision ultimately. Other questions? So I thought I'd end with the top 5 do's and don'ts if you are confronted with a government investigation. The first one, and maybe really the only one we need to talk about, is do not go to jail yourself. What does that mean? Well, as I say here, a lot of people get into trouble for what they do after the investigation starts, not for what was done that's being investigated. It's the old Watergate rule. The cover-up is worse than the crime. That's still true to this day. Okay? And so, as I say, obstruction of justice, cover-up is worse than crime. Nothing will pique a prosecutor's interest more than the whiff of destruction of evidence or witness tampering. Oh, once you get that stench on you, you're in a world of trouble. Okay? So you want to stay away from doing anything that could possibly be viewed as tampering with witnesses or destroying evidence. So what do? The 2 main things is immediately get a litigation hold in place. Have your internal or external counsel, whoever you're doing, draft up a litigation hold, which will tell everybody who gets it, do not destroy anything, keep all the backup tapes, don't alter any emails, nothing. Keep it all. You need to lock down the information that is in existence at the time you found out about the investigation. Man, if you get a subpoena on Monday and the government finds out that on Wednesday you guys wiped your backup tapes, get yourself private counsel. And don't talk to witnesses about substantive issues. This is the harder one. This one most people have no problem with whatsoever. This one some people find damn near impossible to do. Okay? They want to go, the CEO, for example, wants to go and start talking with everybody, or the CFO or the manager or whoever. And they want to start talking to the people and find out what happened. The problem with that is those are not privileged conversations, which I'm going to get to in a minute. And, the old saying of prosecutors and agents looking at everything through dirty glasses, they're not going to look at it necessarily as you trying to gather information. They're going to look at it as you trying to tell the witnesses what they should say. So do not do that. What do you do instead? Number 2, you contact counsel immediately. Okay? Doesn't matter whether it's in-house or outside. Whoever you decide is going to be running this investigation, you get counsel on board right away. Because you need them to help you with the 2 steps I just said. You need counsel to draft that litigation hold to make sure it gets to the people it needs to get to. You need counsel to start talking to the witnesses because they will give you a buffer. Okay? They will give you a buffer for a couple of things. Number 1, if counsel's talking to the witnesses, that's not witness tampering. At least the prosecutor's not going to necessarily view it that way. Okay? More importantly, your lawyer is going to call up the assistant U.S. attorney and say, I represent so-and-so company and all the executives. Well, at that point, you don't have to worry if you're one of those executives. You don't have to worry about an FBI agent knocking on your door at 7 in the morning. Okay? Because they got to go through counsel. Those are the rules. Once they find out that the company or the executives or whoever is represented by counsel, they cannot make direct contact with those individuals anymore. They must go through counsel. That alone is a reason to get counsel involved right away and let the government know it. People often say, well, won't they think I have something to hide if I get a lawyer involved? They're investigating you. They think you have something to hide already. Get your lawyer involved. It allows gathering of information to stay confidential. As I said, if your manager, if the CEO, if the CFO starts interviewing witnesses, the government can subpoena and starts writing down notes and stuff like that. The government can subpoena those. Okay? If I'm the lawyer and I go in and interview a witness and write a memo, that's attorney work product. That cannot be subpoenaed. And again, we're going to be cooperative to the government, but we want to be cooperative in the best way possible for the company. That means keeping our information to ourselves and figuring out how to best package it and give it to the government in a truthful way, whoever is taking this. And the agents and the prosecutors, as they go along, you want your counsel to develop a relationship with either the lead agent or the assistant U.S. attorney if there's an assistant U.S. attorney involved. Because it is a club. I mean, that's just the way it is. They're more likely to get information over the telephone than any employee of the company is. What are they really looking at? How long do you have a timetable when this is going to be over? That sort of thing. They won't always, some of them won't tell you squadoosh, but some of them, once they get comfortable with the attorney, you can get some pretty valuable information about where their heads are at, where it's going, and that helps guide your internal investigation, make it more efficient. Don't volunteer information. Now, this might sound contrary to my initial thing of you want to cooperate from this, but it's really not. Okay? You want to be cooperative and you want to be truthful, but you don't want to hang yourself or drag things out. This is just like if any of you have ever been deposed and you've been prepped by a lawyer who knows what he or she is doing, they will tell you, answer the question, but only that question. Okay? Because the minute you start giving additional information, even volunteering innocent information, can prolong an investigation for months. One little new thing they hear about that they hadn't thought about before, and suddenly 4 more subpoenas have been issued. Okay? That's just what happens. You don't want to give an oral statement, because you may find yourself violating don't go to jail yourself. Why do I say that? Well, remember Martha Stewart? What was she convicted of? She wasn't convicted of insider trading. She was convicted of lying to an FBI agent. Okay? If you say something that is not true to a federal agent, it is a violation of Title 18 of the United States Code, Section 1001, which is a felony punishable up to 5 years in jail. Okay? And you might say, well, I'm not going to lie. How am I going to lie? No, you're not going to purposely lie. But if they ask you who got this email in a little interview they're having with you, and you say, well, did you share this email with anybody else other than who's on the distribution list? No, I never. No, oh no, I didn't give that to anybody else. You might honestly not remember that you gave it to the main guy who did all this. And they find out from looking at his hard copy file, oh, he's got one with your initials on it. Now, that's it. You know that's an innocent mistake. The agent looks at that as a 1001 violation. So do not give an oral statement without your lawyer being there. And if your lawyer allows you to give an oral statement, find a different lawyer. Nothing is, except under very limited circumstances. Nothing is off the record. I can't tell you how many times I've talked to people, and when I say contact your lawyer immediately, I mean when they show up with the subpoena, while they're still there, get your lawyer on the phone. Because here's what they're going to do. They're going to try and interview people. Okay? They're going to try and do it if they have a search warrant. They're going to try and do it if they have a subpoena. Because that's a freebie. They haven't been told you're represented by anybody yet. They can talk to whoever will agree to talk to them. And nobody ever tells a federal agent, I'm not talking to you, when they show up with a subpoena. People don't do that. And so it's amazing how many times I'll get a call from, hey, they served a subpoena a few hours ago, which already makes my hair stand on end. Well, did anybody talk to them? Oh, yeah, but it was nothing formal. I mean, they didn't take notes or anything. They just asked us a few questions. Nothing is off the record, okay? What they do, as soon as they finish with you, they go back to their offices and they type up a memo of the interview. You don't think it was an interview, but you've been interviewed, okay? The FBI form is called the 302. Each agency has its own form. And they will say, I identify it will look very official. It will look nothing like what you thought it was. I'm not saying they changed what you said, but what I'm saying is you think you just had a off-the-cuff kind of chit-chat with the agent, and suddenly it's memorializing this thing that looks like sworn testimony. Even voluntary information, I said, is that subpoena or a search warrant. Well, search warrants are going to go find what they need, but you want to give them everything they ask for, but only what they ask for. And again, you want to talk with your lawyer through that. Okay, the subpoena, you're usually going to have several weeks of time to get everything together. But just like this, you don't want to give anything more than what they ask for because you don't want to prolong this agony. You do want to gather your primary evidence to tell your story. That's the internal investigation. And the real struggle in an investigation, until you get to culmination, is a struggle for information. If you can stay ahead of the government, you are 90% of the way to getting this to a good resolution. Okay? You want to be proactive. You want to be able to guide the investigation. If you're good, if you do a good internal investigation and you're cooperating well with the government, you can guide the investigation to a certain extent. You can start pushing them down the path that you think is the most relevant and not have them spend an extra 6 months going off on a wild goose chase that's going to cost you time and money. If you just sit back and be reactive, God knows where they're going to go. And the old saying of, once the camel gets its nose under the tent, who knows what it's going to find? That's what happens with these things. So you want to grab that information, get ahead of the government as much as you can. Once you figure out the main issue, get the documents and the witnesses who really know the facts, and I'll talk about that in a minute. You want to shut down avenues of the investigation as quickly as possible. As I said, you want to stop that snowball from rolling down the hill, because the more resources they put into it, the more they're going to want to justify all those resources at the end of the day. If they spend 2 months on an investigation, they can let it go without doing anything. If they spend 2 years on an investigation, it's very difficult for them to let it go without doing anything, because they're going to have to answer to their boss as to what they just did for the last 2 years. But remember, this is all got to be done through counsel, because you're going to violate rules 1 or 2, or 2, if you do it yourself. Finally, do assign someone who is really good as the point person of the investigation. This might seem like a silly rule, but this is not considered in the company a plum assignment, surprisingly enough. And so often it will just get dumped on someone. Oh, Bob doesn't have much to do. Give it to him. Okay? Not a smart thing to do. Not a smart thing to do. This is going to be a very long process. Okay? Whoever your counsel is, be it in-house or outside counsel, they're going to need someone who really understands the business you're in and the business organization and how your company runs to help them interpret the information they're getting. If you just give them some, functionary off on the side, they're not going to be able to tell them, how things are really done in the company. And that's very important for your counsel to understand. Okay? It's management, on the other hand, so your counsel needs somebody who they can rely on to give them relevant, complete, accurate information to guide the investigation. And then management is going to need somebody as a single point of contact to keep them properly apprised, to keep the board apprised of what's going on. All right? You have a functionary doing it, and it gets, you play a game of phone, telephone call through 3 people. By the time the reporting gets up to the board, it's just not anything of what's actually going on. All right? So you want somebody who's smart, who's organized, who's available, and hopefully who has institutional knowledge. Some of these investigations go back years, and the biggest problem, sometimes it's unavoidable. Sometimes there's just nobody left at the company. There's been a big turnover in the company, and nobody is there anymore from 5 years ago when all this took place that they're looking at. It is what it is. You play the hands you're dealt. But if you got somebody who has the institutional knowledge going back, then they can be invaluable. There are times when you're going to want to do a voluntary disclosure. And I'm going to wrap up right quick. I'm getting close to my hour. We've talked so far about investigations, government-initiated investigations. Well, there are going to be times when you want to self-disclose. There are times when you're required to self-disclose, as I talked about earlier, if the contract is of a certain value when you're dealing with the government. Okay? Again, you're sort of going to be doing the same thing. It's just you're putting together the package and the presentation to the government without them knowing what's coming. Okay? You still do your internal investigation. You get all the witnesses. You get the evidence. You put it into a nice package, and you present it to the government. Risks and benefits of voluntary disclosures? Well, sometimes you have to. It's a legal obligation. There's really not more to be said. And taking the risk that the government won't find out is a huge risk. And if they find out you knew about the problem, you were under an obligation not to tell them, and you didn't, you're suddenly at least in false claims land, if not in potential criminal land. You're beyond administrative help at that point. Okay? It limits your exposure to a whistleblower, key tam claim. Okay? If you go to the government first, when they get a whistleblower coming in, no valid whistleblower claim because the information's already been turned over to the government. That's a big benefit. Okay? It says may result in a smaller penalty or no or a light CIA. It's most likely going to do that. Okay? They're just not going to be as harsh on you if you voluntarily self-disclose. And this links into the CIA thing, it will evidence that you have an effective compliance program. Okay? You've got a program in place that makes sure you're doing things right, so we don't need a corporate integrity agreement, government. That's how we found this and brought it to you. The risks, obviously, there are risks. You may initiate something bigger than you anticipated. That's certainly possible. There's no guarantee of a favorable outcome. There's no immunity from prosecution when you initially self-disclose. That is a risk you're taking. And obviously, if it's something that's going to get out into the public, settlements are usually reported by the government. They'll send out a press release on a settlement. That can damage your public image. But you really need to look at the benefits. It is often a hard step to take, especially if you've never been through one before. But man, any company who's been through a government-initiated investigation never wants to go through one of those again. And they will gladly self-disclose something if they know it's something they could get in trouble for to cut down any potential exposure. Typical lesson learned from investigations. You must document everything, especially if you're dealing with government contracting. If it ain't in the documents, it didn't happen. That's how the government views it. If the contracting officer told your point of contact, oh, you don't have to follow that regulation. Unless there's an email from the CO saying that, you can say that to you blue in the face. Government ain't going to care. Must record your compliance efforts. Obviously, if you have a written compliance policy, you have that. You want to keep track of all the training you give everybody, any internal audits you do, all that sort of thing. Again, so you can show the government we're a good corporate citizen here. We don't need a CIA. We don't need Big Brother looking over our shoulder. And make no assumptions regarding ambiguous language. You know, this is very different than a normal business relationship. Especially, again, I'm talking about government contracting. In a normal business relationship, you got ambiguous language in a contract, you say, hey, well, they drafted the contract. It's on them. I'm going to interpret it this way. They should have drafted it more clearly. That's fine with the digit or the widget manufacturer you're dealing with. That's not fine with the government. Okay? Normal commercial practices do not necessarily hold. That's what I was just referring to. And again, your contact and the reviewer are very different entities with different marching orders. That's what I was saying before about the difference between an OIG and the contracting officers. 2 minutes to go. Any questions, or have I tired you out?
Did a hell of a job.
Thank you. Yes, Senator.
One question: you're telling your clients, if a FBI agent walks in, hands you something, or starts talking to you, you tell them you want to talk to your lawyer. Say, for example, you grab a phone and frantically call, you can't get the lawyer on the line. You can't get a hold of anybody.
Right.
You can tell. You're going to be hard pressed to tell them, hey, I can't talk with you, but
that's what you should do, though. It's hard to do, but if you tell them, I am represented by counsel, and my counsel has previously told me I cannot talk to a federal agent without him or her present. So I'm sorry I can't talk to you. Blame the lawyer. We get that all the time. Blame us. You are on marching orders. Do not talk to federal agents. And yeah, if you can't get a hold of your lawyer, you just tell the agent, I'm sorry you can't interview me or any of our staff. We're all represented. That's it. They're not gonna, that's not cooperating with them. They're used to that. Okay? Anything else? Thank you all.